Good afternoon. This webinar offers closed captioning. To enable closed captioning, click on the live transcript button on the bottom of your screen and choose your preferred method. Welcome to the Chicago Department of Business Affairs and Consumer Protection webinar. Please note any website or email that I mentioned will be posted in the chat. For those seeking business license assistance, you can visit the Small Business Center here at City Hall or call 312-74-GO-BIZ. Also, business license can be applied for or renewed online at chicagobusinessdirect.org. If you are a part of the BACP Entrepreneur Certificate Program, you can get credit for joining this webinar by sending an email to bacpoutreach@cityofchicago.org. This webinar is being recorded and will be available at youtube.com/Chicago BACP. We encourage all attendees to please ask questions and use the chat box to send your questions. There will be a Q&A session at the end of this presentation. Today's presentation is entitled Tobacco Retailer License, presented by the Department of Business Affairs and Consumer Protection. And to get us started, I will turn this webinar over to Lauren Smith for us to begin.
All right, I'm going to be covering tobacco retailer licensing. I'm a business consultant supervisor here at BACP. We're going to do an overview, go over the license requirements and application requirements. We're going to go over business compliance and also safety tips. All right, to start off, my department, BACP, ensures a fair and vibrant marketplace for businesses, workers, and consumers in the city of Chicago. BACP licenses businesses and public vehicles, regulates business activities, protects consumers from fraud, enforces Chicago's labor laws, partners with business service organizations, and provides education and resources for businesses. All right, so to start off, we're going to go over tobacco dealer basics. There are two types of tobacco dealer licenses defined by the following business activities. First is retail tobacco dealer, which is the most common type. It's an over-the-counter. A retail tobacco dealer is any person selling, offering for sale, exposing for sale, or keeping with the intention of selling or exchanging at retail tobacco products or tobacco accessories in the city. The term retail refers to the sale of commodities in small quantities directly to the ultimate consumer. Secondly, we have wholesale tobacco dealers. A wholesale tobacco dealer is any person making, manufacturing, or jobbing cigars or selling, offering for sale, exposing for sale, or keeping with the intention of selling or exchanging or delivering at wholesale any tobacco, snuff, cigars, cigarettes, or cigarette papers, including leaf tobacco, or any preparations containing tobacco. The term wholesale refers to the sale of commodities in quantity, usually for resale, as by the retail merchant. No sales directly to the ultimate consumer. Wholesalers who also conduct retail sales will require a retail tobacco dealer license. All right, next slide. All right, so I'm going to go over the key definitions. First, there's tobacco products, which means any electronic cigarette or any product in leaf, flake, plug, liquid, or any other form containing nicotine derived from tobacco or any other source. And that's described by Municipal Code 4-64-100. The same municipal code describes tobacco accessories as cigarette papers or wrappers, pipes, holders of smoking materials of all types, and any other item designed primarily for the smoking or ingestion of tobacco products. Flavored tobacco product. It means any tobacco product other than liquid nicotine product that contains a constituent that imparts a characterizing flavor. Retail tobacco store, it means a retail establishment that derives more than 80% of its gross revenue from the sale of a certain tobacco products, and in which the sale of other non-tobacco products are merely incidental. Hookah bar means an establishment where patrons share flavored tobacco from a communal hookah or similar device while seated. And it must be in a freestanding building, among other requirements. All right, next slide. So we're going to go over the application. So basic application information. First, you want to ensure that your proposed business location is properly zoned. Use the Chicago Business Zoning Guide and Zoning Map, and always consult the municipal code and the city staff. So what that means is the first thing we do when we type up an application is we send it to the zoning department, and then they come back with a zoning determination. The second thing you do is you determine your legal entity and ensure that you are registered with all required government agencies. So with the IRS, you get an EIN number. With the Illinois Department of Revenue, you get an IDOR number. And whatever entity you decide to do, if it needs to be registered, you also register that with the Illinois Secretary of State. All right, so third, you'll file your license application with BACP, either in person using a business information sheet, which is online, or you can do an online application through the Chicago Business Direct website. All right, and fourth, the application process will include a background check of all owners, as well as a measurement to ensure that the tobacco dealer location confirms with all relevant distance restrictions. Before you go to the next slide, the background check will require you to get fingerprinted. The fingerprint facility, this application is usually done in person. It's right across the street, but the vendor that we use has multiple locations. Next slide. All right, so the tobacco dealer application. The tobacco license application specifies there's a different form for the applications in two respects. So generally, retail tobacco dealers may not be located within 100 feet of any school, childcare facility, or recreational facility for children under 18 years of age. It cannot be within 500 feet of any secondary school also. No licensee may sell flavored tobacco products within 500 feet of a secondary school unless it is a retail tobacco store. BACP will take measurements as part of the license application to ensure compliance and offers pre-measurements upon initial application to ensure eligibility before the applicant makes a full license payment. So pre-measurement just measures the restrictions from property line to property line, and they measure at the nearest point. Next, the tobacco dealer license applicants, they will undergo a fingerprint-based criminal history investigation of any owner, corporate officer, or any person who has a 25% or more interest in the business, as well as every on-site manager. Each person is charged $40 for the background check. We will ask to see like statements, all statements. If there's somebody else listed as a signatory, they will be asked to be fingerprinted as well. Next slide. Now we're gonna dive more into the location restriction. So the municipal code is wide. So the daycare center may be considered a school. So if you're next to a daycare, that can also disqualify you. Programs or that portion of the program which serves children who shall have attained the age of 3 years and which are recognized by the State Board of Education. Part C describes it as educational program or programs serving children who shall have attained the age of 3 years and which are operated by a school which is registered with the State Board of Education and which is recognized or accredited by a recognized national or multi-state educational organization or association which regularly recognizes or accredits schools. So just to put it in simpler terms, if a park district has a daycare program where they service children, that could be a disqualifier. The code is open. We can disqualify for almost any activities where kids, come and get serviced. To the next slide. All right, so the most common application mistakes are entering into a financial commitment, lease, or other agreement pertaining to your business before you have ensured and verified that your zoning district allows the proposed activity and that your premise meets tobacco distance requirements. So if you have a lease, make sure there's a contingency in your lease, or else you'll be stuck with that contract. Do not assume that the previous owner's zoning designation still applies. This is common. One of the most common cases, Jones Commercial in the downtown district, they expanded their school. Tobacco licenses across the street. It's grandfathered in. If anybody new comes and tries to apply, they won't get it. They'll have to take over the existing license. All right, so the next one, if you're conducting construction or renovation work without the proper Department of Building permits, you won't be able to get the license. The zoning department will look up to see if there are permits on file. If they don't see any permits, the application will be denied until you hire someone that can pull the proper permits for the work. Not doing a pre-measurement to verify your proposed tobacco business location does not violate distance requirements. Now, there's a question in the application where they ask if you want to do a pre-measurement. If you decline and just want to, go forward with the license, we're still going to come out and do a pre-measurement. And if you fail, then, the license fee is non-refundable. So always check state and federal requirements for your business activity. With hookah lounges, there are state and federal requirements. One of them, you have to be that freestanding building. You can't have a building on the side of you. You can't have any residential units in the top of you. So that basically explains that one. To the next slide. All right, so for fees, even though you may have one entity, there are separate license fees required for each business location. The application fees are based on a one-year term. So if you are a retail tobacco dealer, it's $500, and they charge $330 for each register selling tobacco. So if you're selling it for more than one register, you will incur another $330 charge. The license fee for a wholesale tobacco dealer is $550. All right. Turn it over to Adam. He'll take over.
Good afternoon, everybody. My name is Adam Weller. I'm Supervisor of Business Compliance Investigations with the Department of Business Affairs and Consumer Protection, specializing in tobacco enforcement. So we touched a little bit on some definitions from Lawrence, but I'm going to go over some of these a little bit more in detail with some examples of the products. So you know what qualifies as a tobacco product or accessory and what may need a license. So tobacco product is any electronic cigarette as defined, or component or part thereof, or any product in leaf, flake, plug, liquid, or any other form containing nicotine derived from tobacco or any other source, which product is intended to enable human consumption of the tobacco or nicotine, whether chewed, smoked, absorbed, dissolved, inhaled, snorted, or any other way. The reason I pointed out the nicotine is there's different types of nicotine. It doesn't have to be derived from tobacco. So it states there containing nicotine derived from tobacco or any other source, and that's important. Types of products that this would include would be cigarettes, chewing tobacco, vaping products, and vaping liquids. Next slide. And what are tobacco accessories? Tobacco accessories are cigarette papers, wrappers, pipes, holders of smoking materials of all types, cigarette rolling machines, and any other item designed primarily for the smoking or ingestion of tobacco products. The reason that that's important is because tobacco products and tobacco accessories require a tobacco license if you're selling them. So even if you're just selling cigarette rolling papers and pipes, hookahs, but not selling any tobacco at all, you're selling tobacco accessories, and that requires a license. There's also the age restriction on that. So you can't sell those products to anybody who's under the age of 21. Next slide, please. E-cigarettes. So those are any electronically activated device which operates to cause the user to exhale any smoke, vapor, or other substance other than those produced by unenhanced human exhalation. So that includes any device, whether manufactured, distributed, marketed, or sold as an electronic cigarette, an electronic cigar, cigarillo, pipe, hookah, or under any other product name or descriptor. We're seeing a lot more electronic cigarettes these days, and they do require a tobacco license in order to sell. And the products are subject to the same restrictions and rules as all the other tobacco products and accessories that we just spoke about. Next. So touching more on that, they have the same restrictions as other tobacco products. That includes the smoking within 15 feet of entryways. You cannot display them openly. So you can't have any of those products to where I can walk in your establishment, grab an e-cigarette, bring it to the counter, and try to purchase it. Those products need to be behind the counter. I need to request that. You'll then ask for my ID, and then we'll make the transaction. I marked in there the 100 and 500 foot rule, but Lawrence went into great detail about what those institutions are as to where your location can be in order to be licensed. So just a reminder that that applies to e-cigarettes as well. Next. Flavored liquid nicotine. So this is a recent addition to the municipal ordinance. So I wanted to be clear about what this definition is. It means any liquid nicotine product that contains a constituent that imparts a characterizing flavor. As used in this definition, characterizing flavor means a distinguishable taste or aroma imparted either prior to or during consumption of a liquid nicotine product, including but not limited to tastes or aromas of menthol, mint, wintergreen, chocolate, a number of other flavors, but shall not include the taste or aroma of tobacco. So if you're selling any sort of vaping device, vaping liquid, and it has a flavor other than natural tobacco and it has nicotine, it is no longer legal to sell in the city of Chicago. Next. And that's different from a flavored tobacco product. I know we're going over a lot of similar sounding definitions, but these are all different. That's any tobacco product. So we're back to the cigarettes, cigars, chewing tobacco that imparts a characterizing flavor, such as menthol, mint, wintergreen, chocolate, vanilla. So those are legal to sell unless you're within 500 feet of a secondary school. Next. Lawrence also mentioned the retail tobacco store definition, and I want to go over what that actually means. So it's a retail establishment that derives more than 80% of its gross revenue from the sale of loose tobacco, cigarettes, cigarillos, cigars, pipes, and all other smoking devices, in which the sale of other products is incidental. So a couple restrictions are loosened for retail tobacco stores, but not many. Just want to also point out that does not include a tobacco department or section of a larger commercial establishment. It needs to be the entire establishment itself. So retail tobacco store does not include any place that's selling liquor or food or any of those items. You cannot sell those to be a retail tobacco store. You can't fit the definition. And one of the allowances there is that you are exempted from the 500 foot rule for the sale of flavored tobacco products for existing businesses. Next. So still on retail tobacco stores, smoking and the use of e-cigarettes may be permitted in a retail tobacco store, but certain conditions have to be met. must be in a freestanding building. So not part of a larger building and being in your own storefront. It needs to be a standalone freestanding building, solely occupied by the tobacco retailer. So if it's a freestanding building and there are apartments up above where other people have leased out that apartment, it's not going to work. It needs to be solely occupied by the retailer. Can't have liquor or food service, and the smoke cannot migrate into other areas of the building. Next. A hookah bar is a type of establishment where on-site smoking can be allowed. But very similar to some of those rules that I just stated, freestanding building, solely occupied, smoke cannot migrate, no liquor or food. You also may have an additional zoning hurdle to leap over with a possible special use depending on your zoning district. Next. One more. Okay, so on to tobacco regulations. So we have a staff of investigators that will inspect your retail tobacco store once your license has been issued. Our investigators may come in undercover and try to purchase illegal products to see if you're engaging in those sales. Otherwise, they will identify themselves with their city badge and their city ID and announce a tobacco license inspection. So they will be checking the store for full tobacco compliance, and also to be sure that none of those previously mentioned illegal products are being sold. And we'll go over some of the rules of the inspections and some of the additional regulations. So outside of those retail tobacco stores that we defined as 80% or more sales, all tobacco and tobacco products need to be sold from behind the counter. This prevents those products from being in the hands of customers prior to having their IDs checked. This puts the control into the hands of the retailer, and it helps the process as far as obtaining tobacco compliance with the age requirements. No person shall honor or accept a coupon or a price reduction for the sale of a tobacco product. So if somebody comes with a manufacturer coupon for $2 off a pack of cigarette, you cannot accept that. Those are not allowed by the City of Chicago ordinance. Another way that could be disguised is a 3-for-2 sale, a 2-for-1, in order to make cigarettes more enticing and a little bit more affordable. None of that is allowed in the City of Chicago. The exception to that would be buying a carton of cigarettes at a slightly discounted price. It is illegal for any tobacco retailer to purchase, receive, possess, or sell cigarettes unless the package containing the cigarettes bears an unmutilated City of Chicago and County of Cook tax stamp. On the next slide, I'll show a picture of that so you'll know what the stamp looks like. But all retail tobacco dealers need to be purchasing their tobacco products from a licensed wholesaler, and it's the licensed wholesaler's responsibility to then stamp those products and be sure that the tax is paid, and then your cigarettes will have the proper tax stamps on the packs of cigarettes. It's unlawful for any retail tobacco dealer to conceal illegal cigarettes. So it's a separate violation and a very pricey one if we do find illegal products at your store and they are deliberately concealed to evade discovery by our investigators. All right, next slide. So there's the tax stamp over there to the right. Every single pack of cigarettes that a tobacco retailer has in their store needs to have this tax stamp affixed. This is a tax stamp that shows that both the City of Chicago and the Cook County tax have been paid on that pack of cigarettes. It is a pink, white, and black tax stamp with security features in it. We can identify counterfeits fairly easily. We have devices that pick up some of the security markings inside of the stamp. And so it's very easy for us to tell what is legit and what is not. So the cigarettes I'm still on that slide. Thank you. So the tobacco products that are sold to the customers need to be in the original factory wrap packages. There's no opening of packages and selling things individually, such as loose cigarettes, 2 for $1, you know, trying to make the most out of your 1 pack of cigarettes by selling them individually, it's unsafe and it's illegal. So we will cite for that. As mentioned before, the possession or sale of unstamped cigarettes is illegal, and keyword there is possession. You can't have them in your store. And then the final bullet point on this slide states that no person shall sell, give away, or otherwise furnish any cigarette wrapping paper or wrapping leaf that is impregnated with or dipped in alcoholic liquor, chocolate, any fruit flavoring, vanilla, or honey. Now, this is specific to the wrapping paper or wrapping leaf. This does not include such as cigars or blunts that are flavored in this way, but is very specific to the wrap and the rolling paper. So if you have any products that might meet this definition, please check your inventory and be sure that you don't have those offered for sale within your Chicago store. Next slide. So there are record keeping requirements. Every retailer is required to keep a book and maintain an up-to-date record in English of all purchases of cigarettes, including the name and address of the place of business where it was purchased. That includes the date of the transaction, the seller's invoice number, and the number of the city wholesaler tobacco dealer's license. So whenever you're purchasing any tobacco product, as we stated before, it needs to be purchased from a licensed wholesaler in the city of Chicago. A lot of these are well-known in larger establishments, but if you'd like to find an entire list of all wholesalers that you can purchase from, we have that list on our BACP website. Next slide. Okay, so if you have anybody in your retail tobacco store who's under the age of 21, it's okay for them to work there, but they can't have any duties relating to the sale, dispensing, service, or delivery of tobacco products. They need to be entirely hands-off if they're under 21. So they could be working in your deli section while you have tobacco products for sale at the front counter, and that's perfectly fine. But they can't cover for you on break in order to sell the tobacco products. It's also illegal to sell any type of tobacco product or accessories to minors. So anytime an individual comes in the store and requests a tobacco product or accessory, you need to check their ID to be sure that they're at least 21 years of age. We do check every establishment that is licensed with the city of Chicago in order to ensure compliance with underage tobacco laws. And a minor by ordinance is under the age of 21. It used to be 18, but it's changed to 21 about 5 years ago. So it's been in effect for some time now. In addition to that, the city of Chicago has a warning sign that's given to the business owner when the license is issued, and that needs to be posted conspicuously so that we can see that the warning sign is posted. It's a warning that we won't sell anything to the minors. And on the next slide, I have an example of what the warning sign looks like. Next. So here's the exact wording of the tobacco warning sign. It is a violation of the law for cigarettes or other tobacco products or tobacco accessories to be sold to any person under the age of 21. Any person who violates this law is subject to a fine and possible imprisonment. So this is printed on a white card with red lettering. Every tobacco licensee that receives a license is also given this tobacco warning sign. We also have it at the link below on our website that's available for download. If you do download and print out a warning sign of your own, please be sure it's in color because the ordinance does require that the lettering is red. So in case you, for some reason, didn't receive one, or you misplaced it, or it gets damaged, you can always download a new one, print it off, and post it in your store. So we have that link available. Next slide. Another part of our inspection process when we're doing our investigations is that we need some cooperation, and the ordinance accounts for that. So licensees and their agents cannot close and lock doors and safes once our investigators identify themselves and announce our intention to inspect the premises. So if we show up and all of a sudden an employee starts closing and locking the doors and restricting access to various parts of the store, that's a violation, and we will cite you for that. They shall not continue to sell cigarettes and other tobacco products once we've announced our intention, so all cigarette sales must cease. And then within 30 minutes of the arrival of our inspector or investigator, the licensee shall have a person available on site to open any locked safes and doors. So that's different from the first point, because the first one is actively closing or locking. And the third one is if we arrive at your place and there are already locked doors, locked safes, we need to have somebody on site within 30 minutes to open those so that we can tell that no unstamped cigarettes are being hidden or concealed within those spaces. Next. So the fine for any sale of tobacco to a minor is $1,000 to $5,000 per violation. Minimum 1,000, maximum 5,000 per occurrence. So a pretty steep fine. But the fine for many tobacco violations begin at $1,000 or $2,000. So if you have one pack of unstamped cigarettes, that can qualify as a $2,000 fine right off the bat. So these fines are steep. So it's a great idea to comply with all the tobacco rules. Violations that begin at those steep fine ranges include possession of unstamped cigarettes, failure to cooperate with inspections in any of the ways that I just mentioned before, failure to maintain records, accepting price reduction devices, the sale of individual cigarettes, selling flavored liquid nicotine. And each day that a violation continues, it's going to be a separate and distinct offense. In addition to that, if a business has committed a combination of 3 or more tobacco violations within any 24-month period, all the licenses for that business can be revoked. So pretty steep penalties for non-compliance with tobacco laws. Next slide. So in case you want some additional information, I have our website posted here. I know it's a little bit lengthy, but whenever I Google BACP tobacco, it's the first result that pops up. So we have additional information on there, a bunch of links, hyperlinks for rules and regulations, pictures of products that are illegal to sell, and just general good information for any tobacco retailer. Okay, and with that, that will conclude my section of the presentation. Thank you.
Hi, everybody. My name is Sean Barsha. I'm an attorney with the Department of Business Affairs and Consumer Protection since about 2018, primarily focused on prosecuting violations of this type, tobacco violations, but also a host of other violations. And what I hope to do is kind of give you an overview of the administrative court process and some other processes that you may be subject to if you are found in non-compliance for any of the various things that both Lawrence, and Adam have both kind of gone over today. And what I'd like to start with is when you would actually need to appear in a court. Next slide, please. If you need to appear in a court, that means you've been provided a proper notice for that appearance. No one can make you appear somewhere for a legal matter without it first being properly noticed to you. So with BACP, our investigators do have a pre-filled form that is commonly known as either a citation or a ticket, but in Chicago, we call this an administrative notice of ordinance violation, or ANOV for short. What this is a one-page document. You may receive more than one page depending on how many violations you have occurred, but at least one sheet per violation will be issued should your investigation end in an instance that the investigator found you to be in non-compliance. I want to kind of go over just some basic information about this citation first. A lot of folks that I see in court are appearing for the first time in the court in their lives. They really have no idea what any of these terms or items mean. So I hope to just kind of go over some basics first before getting into a bit more of a technical presentation. So what you're looking at on your screen is the top portion of the standard form that we issue as an ANOV. You see the City of Chicago seal on top, and then right below that, circled in red, is the citation number. It'll always start with an R if it's on a form like this, sometimes with a C, If you receive a citation from CPD, it may begin with a P, but for the majority of instances, the citation will look something like this. You'll see an account number next to it and a site number. Those will match your information for your account if you're a current licensee. And then the form will be filled with a variety of identifying information. The respondent is the term that will be used for the person we are asking to respond to the citation. So if you are a licensee that is found in violation, you are the respondent because you're responding to this violation. Your business name, as well as your doing business as name, will be printed next to where it says respondent. Right below that will be the address of your business, as well as your phone number. And then below that is the person served. The person served is the agent at the legal term is locus in quo, meaning your business, your storefront. Wherever the citation was served, that's going to be the person that this citation was handed to. Now, service is proper in the city of Chicago to any agent of the business at the business premises, meaning if you have a clerk who's working in the front of your store, they are able to receive this. Likely what's going to happen is the inspectors will ask for the agent of the business ID if the manager or whoever isn't present, whoever has the most authority at the time, they will copy that information from the ID and it'll be placed on there to prove that this citation was handed to that individual at the date and time in question. So a lot of people get confused when they see their name on this citation. They believe that they may be in some kind of trouble, that maybe they have some liability. But that's not the case. This is just proving that this citation was handed to somebody. That doesn't mean that John Smith, who it was handed to, is then liable or going to be held for this violation. Next slide. And this is the middle of the citation. It's going to show you exactly what you were charged with. Right here is an example of an instance where someone had sold tobacco to a minor. It should be known that BACP is tasked with running compliance programs for checking that each licensee is in compliance for checking IDs. It's a mandated program, so it's something we have to do and something we do frequently. So it's very important that you are checking for IDs, either verifying each time or using some sort of scanning system, whatever works best for your business, as long as you are establishing that the person you are handing that tobacco to is of age. You'll see that where it's a fence, that's going to give you kind of the boilerplate plain language of what exactly happened. Next to it is the code section that you can find. All laws are published in the United States and are available for public consumption, of course. So I'll show you a bit later about how to access those if you want to review, but that would be where to find exactly what you're being charged with. And then you see the description of the action. That just adds a little bit of detail. This establishment allegedly had sold a Blackwoods Russian cream cigar for $11 to a minor. Below that, more identifying information. It'll say exactly where the violation occurred, more likely than not going to be the location where your business is, the date and time that it was issued, and then the notice issue date. If it's sent via mail or on a day other than the day the inspector was present in your store, that date will differ a little bit. And of course, that's completely proper. A service is proper either by handing it to somebody at that business or by mailing it and certifying that mailing. You'll also see at the bottom, there is the signature of an investigator as well as their star number to show that this was an official citation issued by an actual investigator. So when you get one of these, it will have your court date. I think this is cut off a little bit here. I'm not sure that actually, next slide, please. I might have one more. This is all the information you're going to need about your mandatory appearance. This shows you the date you must appear. This one's for August 30th, obviously at 9 a.m., 400 West Superior, and just gives you a bit more information we'll go over in detail. But that's how you will know where and when to appear for any citation that is given to you by BACP. Next slide. So we operate in what is called an administrative court. And I know that might not mean a lot to a lot of people, but an administrative court is a quasi-judicial body that assists with judicial economy. And that's just a really fancy way of saying that there's a lot of folks in Chicago, there's a lot of citations issued, and there's only a limited amount of courts. So this court, why they call it a quasi-judicial body is that it's not a court that's granted authority from the Constitution or from the Judiciary Acts. Rather, it is a court that operates at a lower standard. Any authority for this court to operate will come from the municipal code. It's under section 2-114. Any citation that's issued by BACP will be heard at 400 West Superior, either in room 107 or room 106. And of course, that'll be on your citation, so there's no need to remember that. There are a variety of different hearing locations throughout the city of Chicago. You may, if you've ever gone to pay a parking ticket or a water ticket, likely you've been to one of those hearing facilities, but any citation that you receive from BACP will be heard at 400 West Superior. It's called the Central Hearing Facility. A lot of folks just call it DOAH, which is the acronym for the Department of Administrative Hearings for short. If you have to appear here, you should know a couple of things. One, you do not need an attorney to represent you to appear at this courthouse. Prior to about 2017, there was a mandatory requirement that if you are a corporation with the state of Illinois, that an attorney must appear on your behalf. And this was due to an issue that occurred maybe years ago in the early 2000s, where someone had shown up at this court and said that they had authority to enter into an agreement on behalf of a business when they had no such thing. And it became quite the issue because the business in question didn't know about the debt they incurred because the person that was there really shouldn't have been there. And the court has kind of found a way around making sure that you have authority to be there. We'll get into that in a little bit. But for any citation heard at the Department of Administrative Hearings, you do not need to hire an attorney. The court has a jurisdictional limit per docket. So what that means is that there's a cap placed on every docket that is issued at DOAH. A docket is just a term of art. It's a number, it's a filing system. It just encapsulates a case into one kind of number. So it's just kind of a term of art we use to organize things. But every docket number has a limit of $50,000. And that's not to say that you cannot incur liability greater than $50,000 for extremely egregious situations. For example, Adam had mentioned unstamped tobacco. I call that tobacco smuggling. If you are charged with selling unstamped tobacco, you are likely going to receive no less than 3 dockets due to some legal technicalities that need to take place because of some mandates in the ordinance. So you do have to schedule some expedited hearings if we ever take property from you, and that's one of the reasons why you may receive 3 dockets if you deal in unstamped tobacco, and that puts your cap of liability at $150,000. And of course, if you receive more citations, it's per docket. So if you receive a follow-up inspection and you're still not found in compliance, you could have a ceiling of $50,000 in that instance as well. Even though you are not required to have an attorney, you of course have the right to hire an attorney. I always encourage folks who perhaps are a bit unsure about their ability or their understanding of the law to do so. There are attorneys that are available for free at this location. They can advise you. They won't be able to represent you, but they can advise you. That's something that I can't do. Because I represent the city, it'd be unethical for me to advise you on your citations because I'm prosecuting them. But there are folks there that can help. It's the Carpals program. All that information is available online. There'll be a link coming up. And they are available to talk on, I think, Thursdays at DOAH. And if you are ever there, just say you want to talk to a Carpals attorney and someone there will be able to point you in the right direction. If you are representing yourself and appearing on your own citation, you should know this court isn't exactly as strict as other courts, and that's really to your benefit. We deal with a lot of folks that they're called pro se without an attorney, and we want to make it as easy as possible for you to handle your own matters. What this means is that there are rules in place for this court that do make it a bit less strict. There's not as much as a dress code. You may be kind of shunned by the judge if you show up with a hat or have a phone go off or things like that, but no need to show up in your Sunday best. But obviously, if you show up in your Sunday worst, still might be great. There's a couple of terms here, evidence and hearsay. These are legal concepts that have a different meaning in this court. Evidence that can be used in this court is any kind that is typically used in the ordinary course of business and relied on by the ordinary prudent person. And that kind of just means anything. Like if you believe this is relevant and would help your case, more than likely a judge is going to allow you to present it. Just make sure that you do bring hard copies or at least digital copies of things you may want to submit, because they do need to be tendered to the judge so that they're entered on the record. Hearsay is a legal concept that's a bit complicated, but at the Department of Administrative Hearings, hearsay is not an issue, meaning that a statement that you have heard or a statement that was said can be repeated by a person who did not say it. And so it's a much more lax rules when it comes to an administrative court. Lastly, I just want to mention the Mayor's License Disciplinary Commission. This is another quasi-judicial body. It's held at the 8th floor of City Hall. It's BACP's offices. There is a courtroom there. The Department of Law in the City of Chicago handles cases that we refer over to this commission. This commission is a bit more serious. It has rules very similar to the Department of Administrative Hearings. But the purpose of this really is to enact discipline on the license, meaning if you are subject to discipline and you could possibly face higher fines or even the loss of your license, if that happens, what the typical procedure would be is that you would still receive a citation from the BACP inspector. It would still be scheduled at DOEH, but then at DOEH it'll be dismissed. Not dismissed on its merits, not dismissed because it's going away, but rather it's being removed so it can be prosecuted at the Mayor's License Disciplinary Commission, and all the necessary information that you may need will be sent to you via US First Class. Next slide, please. And I just want to talk to you a little bit about procedure. You'll see a QR code there. Feel free to stick your smartphone camera at it if you want a little bit more information. I believe these slides will also be available afterwards, and there is an active link there you can just click if you download the slides. But that'll lead you to DOEH's website, where you'll receive a lot more information about what I'm about to tell you. And that's just basically what you do on your court day. So if you are scheduled to appear at 1 o'clock at the Department of Administrative Hearings in room 107, you will show up at 400 West Superior. There are some front doors with some security. You will need to go through some metal detectors. Your bags will be checked. No outside food or drink will be allowed inside. So make sure that if you have any coffees or things like that, to finish them before you get there. After you're greeted by security and go through, there are several ways you can go, either straight or to the left. It's kind of a long hallway with a variety of rooms. There's a payment center at the front. So if you do incur a fine or need to pay your water bill, anything like that, you can do so at the front of the building. But typically you would just make a left, head down the hall to where room 107 is. Across from room 107, there is a desk with a court clerk. He or she will be able to assist you in filling out what's called an appearance form. Now, an appearance form is just a carbon copy document. So don't detach that document. The carbon copy is for you after the appearance is written on. There's a lot of standard information that needs to be placed on there, but some of that may be confusing as well. Next slide, please. Next slide, please. And this is just a picture of the appearance form. And some of those terms we talked about before will become relevant when you're filling this out. Right there, there's two spots for a business name and address underneath where it says City of Chicago Municipal Corporation. That'll of course be your business corporate name and the address of your business. To the right of that, you will need to provide the docket number and the ANOG citation number. All dockets will begin with the first two, the last 2 years of the 4. So 2022 will just be 22. It'll be followed by either an RV or a CS, etc., and then several digits. The clerk will be able to assist you in finding what your docket number is. There is a form posted on the wall that houses all the cases for the day, including their docket numbers. And citation numbers if you didn't bring your citation with you. The next you'll have to fill is who is actually appearing on behalf of your business. Now, as I mentioned, you don't have to have an attorney to appear, and in fact, anyone that you deem to have authority to appear on your behalf can do so. So if you happen to receive a citation and can't make it, if you're sick, if you're out of town that day, whatever, you can ask someone to appear for you. It could be a friend, a neighbor, a brother, your employee. As long as you've authorized them, they can put their name there and appear on your behalf. You then need to select, or at least the person who's appearing needs to select what exactly that authority is that they have to appear. At the bottom of this, you'll say if the respondent is an individual, please select one of the following. You'll never, likely would never have to select that. Most folks who would appear will have a corporation or an LLC, something to that effect. So you likely wouldn't have to make a check there. Next slide. But rather right below that, you will have to indicate what your representation level is. You'll see if you're a corporation, which would also be LLC, anything incorporated with the state, you would select one of these 4 boxes. There's one box that generally speaks to employees, owners, supervisors, etc. And most of the time, if you're related to the business in some official capacity, that would be the right box to check. The next 2 are related to being an attorney. If you have an attorney, they'll select that they are the attorney. If not, you can also select the next one, just saying that someone that you told to be there can be there because they've been expressly authorized to do so. And last, you can always just explain, and that's the easiest for most folks. You could just say, I'm their brother, I'm their employee, I'm their neighbor, whichever, and the court will confirm that on the record. So that's usually the easiest. And of course, whoever is appearing needs to sign and fill out their own personal information at the bottom because they're the one appearing on your behalf at that time. Next slide. So what happens after you get your form is that you'll step into room 107, and that's where I will be on Mondays and Fridays. Those are the 2 days that I'm over at DOEH. Those are the days that tobacco and gas station food violations, things of that nature, those are prosecuted on Tuesdays and Fridays. We also prosecute a variety of other different ordinances other days of the week, but if you are a tobacco licensee, more than likely you'll be assigned either a Tuesday or Friday for your status hearing. And that's an important term. A lot of people, when they first come to court, don't have a huge knowledge base of what court is, and they expect their matter to be heard immediately, meaning they want to go before the judge and they want to tell their story. And that likely wouldn't happen the first day. The first day that you're commanded to appear at DOEH is known as a status hearing because the great majority of these are settled. They're not contested. They're not having a hearing in front of the judge. So even though it's called a hearing, it is a status hearing, meaning we're just going to talk about the violation. You can provide me with any defenses you think you may have, but we can discuss the relevant law and what the city's evidence is. But what will happen is once you fill out your form, you'll walk into room 107, you'll hand that to me. I'll likely speak with you immediately. If there's a few more folks, you may be asked to sit down in the courtroom. Of course, be respectful in your demeanor while sitting in the courtroom. A record is running, so everything is being recorded. So it's essential that voices are kept low and phones are off. The negotiation period, I will go over almost everything I'm telling you now, including giving you your options and your rights. The majority of the times what I will do is make you an offer to resolve your case, and that is a monetary fine amount. The fine amount that I can offer is mandated by ordinance, so there's a minimum and a maximum, and I can only offer a fine or issue a fine that falls within those 2 numbers. So for example, tobacco violations, at least the great majority of them, have a fine range of $1,000 to $5,000. So I can't offer anything below $1,000, can't offer anything above $5,000. And there are a couple of terms that just might be relevant. A lot of folks may not have any kind of idea about at all. If you agree to settle your case, what you're really doing is you're entering into a plea of libel to resolve the case. So a plea of libel just means that you are agreeing that the underlying action was committed, you're not contesting it, you agree that I accept this outcome. It's not a guilty plea, this isn't a criminal court, this won't be on your criminal record. But there will also, if you do plead liable, there will be a business record of that, and that'll always be kept within your account. I see that the slideshow may have ended a bit. Are we going to get back, or are we running out of time? But I'll keep going over while this is getting back. There's a couple other terms. The options that are presented to you besides settlement would either be A, to continue the case, and continuances are granted for good cause, or B, if you wanted to set it for a contested hearing. So if you come to court or someone comes to court for you and you are not prepared, typically that is not a good cause reason. But say someone is in the hospital, say someone is out of town, you can't get a hold of them, and someone appears on your behalf, that is always a good reason for a continuance. The judge would likely grant that. I likely wouldn't object, though we do try to handle things there and then on that first day. If you don't want to agree to settle the case, your case could be continued. And another good reason would be if you wanted to speak to an attorney. I'll never object if you need to seek legal counsel. But we're pretty friendly over there. We can give you what information we can. We can't give you advice, but it might be helpful just to discuss your case, just to be prepared for all your options before seeking out an attorney. But again, I encourage everyone who wants to have an attorney to do so. The other motion would be for a contested hearing. That is a full trial-like hearing before the judge. Will not be the first day, as I mentioned. It would likely be within 30 days of the initial hearing. I would then notify the inspector who has issued you that citation to come. The city will have them testify to what they experienced during the inspection. City will also produce any and all relevant evidence that was taken during the inspection, which could include reports from the inspector, photographs, or any kind of other relevant information that was taken during the investigation. Last, in some instances, your case could be dismissed. A dismissal only happens if there's a reason for it. One of the most common ones that I see is a dismissal for compliance related to liquor liability insurance. So some, I know folks may have both maybe a gas station and tobacco license, maybe have a liquor license. You have a duty to post that your insurance for liquor on your wall. But in some instances, if it's not posted, but it still is active and you can prove that to us, your case may be dismissed. Also, if you were able to prove that the underlying offense did not occur, that would be also cause for dismissal. So I will, what I do is I of course read the reports and review the evidence from all of these inspections. And then after that, I speak with you. And then taking both into account, what I'll do is make you an offer to resolve on any of these issues that we have discussed. Last, when we are done discussing, for whatever reason, whatever outcome happens, if it's settled, if it's continued to a different day, you will still need to appear for a judge. They are known as ALJs, administrative law judges. They are not hired by the city. They are neutral arbiters. So they also cannot advise you, but they also do not represent the city's interests. That's what I'm there to do. At the end of that, you'll receive a final order of disposition. And this is just kind of a receipt of sorts. It has all your necessary information on it that we've talked about, and also the outcome of the case. If it was continued, it will say it was continued. If it was settled, it'll say you had pled liable with a monetary fine amount at the bottom. Every docket is charged a cost by the court. Typically, that is a $40 cost if it's over $100 in fines, or $20 in cost if it's under $100 in fines. So if you have X amount of fines, you will always have that additional cost added to it. Next slide, please. And so there is rather a procedure that you can correct a default judgment if you miss your hearing date. So a default judgment is a automatic understanding of liability, meaning no one had appeared at that time. So by not appearing, you agree that this incident happened, and in that instance, the maximum penalty will be lodged against you. So in tobacco instances, the maximum penalty for the majority is $5,000. If you have 4 different counts that are all tobacco related, that could be a default of $20,000. So it's very important that you're making sure you're attending your court hearing, but if not, you do have a limited 21-day window to file what's called a motion to set aside the default judgment. Those can be filed either in person at the information desk at the front of 400 West Superior, but more easily on their website. They do have a link to an email address as well as a standard form where you can file your motion online. Time is of the essence when it comes to these, so make sure that you are filing within 21 days. And that 21 days starts after the default order is mailed to you. So you'll receive a time-stamped default order in the mail to your business, and it's 21 days from the day that it's stamped. If you file what we call a late motion, it'll be sent to the late motion call if it's accepted at all. A late motion is something that's past the 21-day window. The late motion call is something that happens in room 105 at DOEH. It's not handled by BACP attorneys nor law department attorneys. Rather, Chicago is engaged in outside counsel to collect on these debts. And their authority is very limited to collecting these debts. So it's important that you do, one, attend your court day, or two, file a motion in a timely fashion. Last, if for whatever reason you're unable to file a default judgment or your case was not accepted from the late motion call, you still have the ability to appeal the default judgment to the Circuit Court of Cook County. Before doing that, of course, you must exhaust all administrative remedies, and those remedies are what I've just gone over, meaning either filing a motion, or it means filing a motion with the Department of Administrative Hearings. If you haven't done that first, likely you're just going to be wasting some money, because the Circuit Court of Cook County does require that all businesses have attorneys, so it's a little bit different than DOEH. I should mention that if you are required to appear before the Mayor's Licensed Disciplinary Commission, you also are required to have an attorney. So the only instance where you don't have to have one is at DOEH. Next slide, please. And this is just information if you don't actually want to appear in person. Since the coronavirus pandemic occurred, the BACP has implemented a program that we call remote adjudication. And it's a way that you can negotiate and handle your cases without physically appearing. It's all handled through email. It's incredibly efficient and worthwhile. So I can't speak higher of it. If you do receive a citation, it's highly recommended that you reach out to BACP-administrative hearings at cityofchicago.org and provide the basic information for your ANOV. That includes the business name, the address, the ANOV number, and when your hearing is set. And just say that you want to settle your ticket remotely or discuss the ticket remotely. The QR code here also has a link that'll take you to a bit more information about the process. But as long as you send a message within 5 days of the hearing date, someone should be able to respond with an offer to resolve or at least a bit more information. The process for docketing cases at DOEH is such that there needs to be a certain amount of time passes after your citation was issued. It's all very administrative and boring, but the essence of it is that your citation likely won't be entered or docketed by the court until about 2 or 3 weeks before the scheduled hearing date. So BACP attorneys won't be able to actually assist you until that date, but feel free to email us almost immediately after you get your citation if you do end up getting one. This is a general inbox. It's then siphoned out to each attorney responsible for these cases, and you'll likely receive a follow-up message saying that your request has been received, it's been filed away, and then once it's docketed, the appropriate attorney will reach out to you. So it's just a really good way to make sure that you're handling your matters in a timely fashion. Next slide, please. And Adam kind of went over a good chunk of what these violations are. I just want to talk briefly about some of the effects that these common types of violations will have on your license. First off, the fine range can go on exponentially depending on what's happening. And I'd like to give you kind of a perfect storm example that hopefully none of you will ever experience. So if someone is accused of selling unstamped tobacco, and it should be, I use the term selling loosely. The law is such that if you are in possession of the unstamped tobacco in your store, it's more likely than not that you'll be able to be prosecuted just for having it there. Possession is something that the tobacco ordinance takes into account. So in this example, let's say an inspector comes in and you have sold an unstamped pack of tobacco to a minor. That's kind of a trifecta of horribles. That means you're going to be receiving no less than 4 different dockets and at least 4, if not more, citations. And that would include charges like not having your Cook County tax stamp nor your City of Chicago tax stamp, even though they are kind of one, they are technically 2 different violations. You'll also receive a citation that we had to store your property for evidence. In addition to that, you're going to receive the citation for selling to the minor itself. So right there off the bat, you're looking at a $4,000 fine, and that's only guaranteed if it's a first offense. BACP uses a theory called progressive discipline. What that means is that for a first offense, you're likely going to receive the minimum fine because things do happen sometimes. Mistakes are made, and this fine is really to encourage you to learn from those mistakes. If it is a second offense, or worse, a third, the parade of horribles gets worse. Usually the fine is doubled. If you sell tobacco to a minor twice in 1 year, you're likely going to receive no lower than a $2,000 fine just for that one charge. And a variety of these other violations here, I can let you read yourself. Of course, it is illegal to sell cigarettes in a pack containing less than 20. They call those loosies. If you sell them individually, you will receive a citation for that, as well as all of the requirements that kind of Adam has gone over. You are required to keep records, and they do need to be available to be viewed by the inspector during the inspection. So if you, as the owner or the manager, are not on site, your agent needs to know where all of these things are so that they can fully cooperate with the inspection. And then cooperation with inspections, like Adam has touched on a bit, have a variety of different aspects. If your clerk does not have a valid ID on them when they're selling tobacco, that would be a violation. If no one is there to open your safe within 30 minutes of the start of the violation, that would be a non-cooperation instance. And one thing that is kind of tobacco related, at least we see a lot of this in tobacco locations, is drug paraphernalia. Specifically, I'm talking about glass roses. These are deemed to have no other quality besides the ingesting of drugs. So they are deemed drug paraphernalia, and that does have a higher minimum fine. That's a $2,000 minimum fine. So all this isn't really meant to scare you, but really to inform you, because you need to protect your license. When you're acting as a tobacco dealer, you're going to have distributors and folks trying to get you to sell their products, and a lot of distributors will want to sell you these glass roses. So it's important to know what is and what isn't acceptable. Next slide. And this next slide also is a link. I know it's a lot of words right now, it's an image, but that link will bring you to American Legal Chicago. That is where all of Chicago's ordinances are published. Tobacco laws are published under Chapter 464, and then the entirety of the chapter would be in effect. So I really encourage everyone to click on that link, or even just Google American Legal Chicago, comes right up. And review the entire ordinance. There are also tobacco rules available at BACP's website. I encourage you to review those as well, because there are a lot of things that you could be charged a lot of money for if you don't have the knowledge base. What I'm going to finish with is the most unfortunate situation that could happen to your license, and that is a revocation or a non-renewal. So in the city of Chicago, if you receive 3 or more, or even 2 or more of a certain type of violation, it's mandatory that we revoke your license, and not only will your tobacco licenses be revoked, but all of your licenses will be revoked. And of course, if your license is revoked, there is a moratorium on that location. So a person you wish to sell your business to may not be able to hold a tobacco license there. And it does kind of create a parade of horribles that you really need to guard yourself against. So I won't read off which code sections are strikes, but the most egregious are strikes. I'm calling them a strike, meaning if you get the 3 strikes, you're out, meaning you're revoked. And those are any of the tobacco, unstamped tobacco smuggling charges we talked about, selling tobacco to a minor, not having that tobacco warning sign, selling flavored tobacco, flavored tobacco wraps, selling flavored nicotine, liquid nicotine rather. or not having your records available for review. Any of those, if you get 3 or more of those in a 24-month period, we will be forced by law to revoke your license. The 2 and 4 is for the Lucy cigarettes that I've kind of discussed. If you are charged and found liable for 2 offenses within 24 months, that is also a revocation. So again, I really do encourage you to review the ordinance in its entirety if you plan on being a tobacco licensee. And I'll hand things back over to Stella to wrap up.
Looking at the chat and the Q&A box for questions, it doesn't look like we have any. Let's give them a couple of minutes to type up their questions. Let's see what happens. Okay, it looks like we don't have any questions. And look, that means this is a good presentation. You all answered all of their questions that they probably did have when they entered today's webinar. Thank you again for your time. And if you would like to receive credit for today's webinar, please send an email to bacpoutreach@cityofchicago.org. Again, that's bacpoutreach@cityofchicago.org. Thank you.